Okay. I apologize for imposing. Please allow me to speak a little bit about what people, especially parents and children, being litigated against by the state in the province of Ontario's Provincial Court, Administrative Law Court. Please research that. It's very, very important. By the Children's Aid Society, Child and Family Services Act, what people need or could potentially learn if they had the incredible amount of time and resources which are needed. When the Children's Aid Society begins to look at attacking your family, the very, very first thing that you have to do is get into your local public library, get to the law section, and start taking out books on political science, law, criminology, journalism. The amount of knowledge that you're going to need to survive litigation in the province of Ontario's wickedly secret administrative law court is really indescribable. I tell people that not in all cases, but if the Children's Aid Society flicks that malicious litigation switch, which they often do, if the Children's Aid Society decides to become malicious towards your family, you're going to have the knowledge of a university political science professor, law professor, journalism, all of it combined into one. In journalism, they teach you how to investigate. And that's what you're going to have to become. You're going to have to become basically a world-class investigator. And one of the reasons is because if you are a low-income Ontarian and you qualify for Legal Aid Ontario, under no circumstances should you expect anything but a farce of a representation by the Legal Aid Ontario lawyer. There's a term that is used. It's called dump trucking. And it's when lawyers, almost always Legal Aid Ontario lawyers, working on certificates, go through the motions of providing a correct representation for an individual, but in fact, they are tanking the case. They are only going through the motions. It's called dump trucking. And the occurrences of dump trucking in the courts of Ontario being perpetrated by Legal Aid Ontario lawyers is extremely severe. Litigation in common law countries such as Canada, Westminster, Buckingham Palace, has been created to be incredibly convoluted. It literally takes many, many, many years of very, very dedicated university-level reading and study to get to a point where you have the knowledge to defend yourself in court. If they decide to become malicious. They don't always decide to become malicious, but if they do, you're going to need that type of knowledge. So you get into your public libraries and you see what your local library has. Take out a law dictionary. I like one called Carswell. Carswell Pocket Dictionary of Canadian Law, 5th edition. In those law dictionaries, you're going to learn about something called doctrines. Doctrines are these magical, mysterious principles or rules which have been developed and created and imposed and entrenched by common law court judges in the Westminster Buckingham Palace jurisdictions, which Ontario is one. You have to understand what doctrines are. One of the nastiest doctrines known to man, a lot of them are in Latin. One of the nastiest ones is called, and I might not pronounce this correctly, parens patriae. And what that means, it translates to parent of the nation. And the courts and judges have given themselves an unchallenged unqualified, just galactic power to basically take the role of parent of any child born in a Buckingham Palace jurisdiction. Another nasty one of the nastiest, is something called a presumption of regularity. I forget the Latin, but it translates to a presumption of regularity. In the province of Ontario Court of Justice, where 99% of Children's Aid Society litigation begins, there are only a couple of locations in Ontario that don't have provincial courts. And in those cases, the litigation begins in the Superior Court, where the family has a few more rights. But most of the litigation begins in the provincial court. And provincial courts do something called administrative law. If you're ever charged in a provincial court under the criminal code, just watch how very, very secretly the Crown Attorney, without any notice to you, will change your criminal code charge into a Provincial Offences Act charge. It's incredible that they're able to get away with it. It's incredible that the legislators, the MPPs, have not stood up and done anything about any of this. But in the administrative law courts, the judges administer the province's legislation. Please understand that and research that. The judges administer the province's legislation. They do not adjudicate trials based on the evidence. They administer the province's legislation. Ontario has over 300 pieces of provincial legislation. You can find them on a website called e-laws. You know some of them: the Highway Traffic Act, the Child and Family Services Act, the Trespass to Property Act. There's over 300 of them. The judges of the Ontario Court of Justice, which is the largest and most expensive court to operate in Canada, administer the Child and Family Services Act. When you hear people say that the Children's Aid Society private corporation has more power than the judges in the provincial court, that's what they're talking about. Because in fact they do. And it's called administrative law, and it's really, really nasty. So this presumption of regularity is this dirty, dirty thing that the justice system participants came up with. And what it means is that if you are a justice system participant, if you're willing to sell your soul to the Buckingham Palace fraud and participate in that system that does so much gratuitous damage to people, the presumption of regularity establishes in the eyes of the court that all of you within the justice system participants are automatically presumed to have acted correctly. Can you believe that? So families will sometimes talk about how the Children's Aid showed up at their door with a cop. The Children's Aid lawyer or the Children's Aid worker made allegations. The family begged the cop, come on into our house. Look at our cupboards. Look at our home. Speak privately with our children. Do any type of investigation you want, officer. Our children are loved and cherished. There is no abuse. The cop will never tell the family this, because it's always about operating in secrecy. But because the Children's Aid Society worker is another justice system participant, the cop is legally allowed to take action under the presumption of regularity. And despite the clean house and the smiling and happy children and the parents who are willing to be investigated by a police officer, the cop will allow the apprehension to go ahead. And that's the presumption of regularity. It's the same when the baby snatchers make allegations in their affidavits. It's the presumption of regularity. The administration of justice in the province of Ontario is a disgusting cesspool. And of course, people have no respect for you. So you get in the library, you get the legal dictionaries, you get, there's another good one called Law and Legislation for the Social Service Worker. If you contact me at my Facebook page, Scrutinizing the Justice System Participants, I'm happy to provide more titles. But your local public library might not have a whole lot. So that's going to require you to invoke your rights under the Public Libraries Act and utilize something called the Interlibrary Book Loan. In Chatham, Ontario, my public librarians, all I do is send them emails with links to the books that I want, the titles, and they go out all throughout Ontario, including the universities of Windsor, Western Ontario, and Lakehead, who they have agreements with. They'll even go outside of the province to bring the books in. And that's how ridiculous litigation is in Ontario. Lord help you if you're a construction worker doing 12-hour days. Lord help you if you're a nurse doing 50-hour weeks. Lord help you if you're a teacher who has to do her marking at home after her regular hours. You will absolutely not have the time to do the reading, the time or the energy to do the reading you need to do to survive in the courts of Ontario. So you get to the library. Another thing, and for sure, Vern Beck of Canada Court Watch deserves all the respect for this, for making the people of Ontario aware of their right under Section 183.1 of the Criminal Code of Canada. You have the right to record your interaction with other people. And you don't have to tell the other person that an electronic record is being made. And that electronic record can eventually become evidence in a trial. There have been many families in the province of Ontario. I know one particularly fierce mother out of the region of Waterloo who have been able to save their children from Crown Wardship no access to families. So the Children's Aid has the family in court for a couple of years. They're moving towards the trial. The parent tells the Legal Aid Ontario lawyer, and by the way, Legal Aid Ontario lawyers will tell you not to record Children's Aid Society workers, even though it's the best evidence you could ever get. Recording all your meetings, all your telephone conversations with them, all your visits at the Access Center, the best evidence you'll ever get. Your Legal Aid Ontario lawyers will tell you not to do it. So Children's Aid is saying, oh, Your Honor, the only way we can protect these children is to make them Crown Ward without access to the family. They're weeks away from trial. And the mother tells her lawyer, guess what? I have hundreds of hours of conversations recorded with the Children's Aid.
So think about it.
And I want to enter those recordings into the trial as evidence. The lawyer, the Legal Aid Ontario lawyer, will stand up in court and he'll be all flustered and he'll say, oh, Your Honor, I had no idea this was occurring, but my client just told me that she has hundreds of hours of recordings of the Children's Aid Society. She wants to know how the recordings should be entered into the trial as evidence. Does the court want the recordings or does the court want transcripts? The Children's Aid Society lawyer will stand up, he'll look at the worker, he'll look at the judge, he'll look at the mother, he'll look at the judge. There'll be a few nods that'll be exchanged. And the Children's Aid Society lawyer will say, we need a recess. They will step outside of the courtroom. And remember, this is a case where "Oh, Your Honor, the only way we can possibly save this child is to make him a Crown ward without access to his family. No other court order will suffice." They'll step outside of the courtroom, and the Children's Aid Society lawyer will say, "Okay, we've had a change of heart. We're sending little Billy home." Only because the mother had made recordings of her interaction with the workers is the Children's Aid Society all of a sudden ready to send the child home. The Children's Aid Society lawyer hasn't heard the recordings. The Children's Aid Society lawyer hasn't seen any actual evidence of the recordings. But just the possibility that hundreds of hours of conversations with the Children's Aid Society worker can be put on the public record is enough to scare the lawyer into wanting to settle the case. And remember, seconds before, it was a case where the only possibility of protecting the child was a Crown ward no access to family order. The administration of justice in the province of Ontario is a cesspool. The only reason you're able to get away with your criminality is because you jury-rigged the legislation and the litigation. You wouldn't survive 2 weeks under the Freedom of Information and Protection of Privacy Act. We would bring you to heel like the public servant, queen-swearing dogs that you are.
Goats and goats! I just want to say, hey, remember 2 years ago a foster parent killed himself because he was scared to go to jail? Remember that case? Yeah. 2 years ago a foster parent killed himself because he was convicted and he was scared to go to jail. 2 years ago. And he looked this great.